Good evening and welcome to Slam the Gavel, the show that tells it all regarding family court and CPS issues. I'm your host, Marianne Petrie, and today I have a return guest. His name is Michael Sayen, and the last time I had him on was December 23rd of 2020. Now, back then, we were discussing the difference between state law and the federal Constitution regarding the best interest of the child. Today, we have a lot of topics we're going to cover. We're going to cover unilateral contracts and what that is. We're going to cover biblical marriage and what defines marriage. We're going to talk about the lovely issue of family court and how did they get started with that. We're going to talk about parents patriae, best interest of the child standards and where it's headed. And we're also going to talk about the role of the church today. So we've got a lot to cover. Good evening, Michael. How are you doing this evening?
Hey, well, like I always say, you don't go to the hospital unless you're sick. You don't go to the church unless you need to be saved. And you don't go to family court unless something horrible is happening to your family.
Exactly. Yeah, and no one wants to go there. People don't realize
That's right.
what's in there.
That's right. Whenever you have family and government together, anytime a government has something with the word family in it, or Planned Parenthood, anything to do with family or parenthood, stay away from, because you know that the government does not need to mix in the family unit.
Right. Yeah, they just make a big mess of it.
That's right.
Now, so do you want to go in order of, do you want to talk about unilateral contracts and what that is?
Yeah, let's go ahead and start off with defining marriage and why, and then we can go right into unilateral contracts and why that's important, because we have the big question of unilateral no-fault divorce and how that changed our society drastically. So let's go into the basic fundamental biblical understanding of marriage and what marriage is. A lot of people, it's actually surprising, a lot of people as well as Christians don't really understand what marriage is. They don't really know how to define it, but the Bible is very clear to define what marriage is. People ask, is it a state institution? Is it a private institution? Is it a religious institution? Who has the authority? Is it a sacrament? What makes marriage? Two becoming one flesh. What about common law marriage? So there's a lot of questions that people have when it comes to marriage. And the reason why that's important, because when you're dealing with the state or the nation all over the world, having direct influence or at least being a part of or recognizing a marriage, marriage is one of those few things that actually connects religion and state law together. It connects the two together. And it always have through all of history, because the states have always recognized marriage. However, marriage has always fundamentally been a religious institution.
Mm-hmm. Mm-hmm.
So if you had to, and then cut in any time you want, but if you had to ask what the definitions of a biblical marriage are, the biblical marriage is very simple. What makes a marriage is the two people making a covenant together. Mm-hmm. That's going to be that promise or an agreement, as we would say, or a contract. Oops, sorry, did you hear that?
I heard that. Sorry about that.
That might have been me. So, oh, it's pretty loud. Sorry about that. So what I might do is I might drive it as we speak, just because it looks like the traffic's a little loud around here. Okay. What we're going to do is when we talk about biblical definition of marriage, we actually go to the word. We actually look at all the context of the Old Testament and say, what are all the pictures and the fundamental pictures that we get of marriage? How is it used? Because it talks about marriage in a pagan sense, in a biblical sense, in a Jewish sense, in a historical sense. The Old Testament, especially the book of Genesis, is the beginning of life. We have Adam and Eve, historical records of that were written down by Moses. So Moses was the actual the author of who actually wrote down the first 5 books of the Bible. And that was mostly passed on by unwritten stories from the Jews. So we have a basic foundation of marriage as we look through it, and we see that marriage basically is the two becoming one flesh, right? We have the basics of of marriage was a design of marriage from the very beginning with the animals in Genesis chapter 1. Genesis chapter 1, God made the animals, and he made all things. He asked Adam to name all the animals. What Adam did was, in naming the animals, he noticed that every single animal had a primate. There was a mother and a father. And he actually brought, and you see in the book of Genesis that he actually brought that question up to God. It's like, God, why he was all alone. He's like, why do all the animals have pairs? Where is my pair? So he obviously could tell that the difference between a male and a female animals. And so he asked God, he's like, God, where's my pair? And God put Adam in a deep sleep, took a rib out of his side, and created Eve from Adam. And this is where you get that the word woman came from the word man, Isha. And so from there we have the understandings of marriage, because God goes on to a basic fundamental prophetic word in Genesis chapter 2, and he says, a man shall leave his father and mother and cleave to his wife, and the two shall become one. The reason why this is important, because Adam at this time did not have a mother or father. So you would have to ask yourself, well, wait a minute, why did God say a man shall leave his mother and father, cleave to his wife? Shouldn't God have just said to Adam, hey, cleave to your wife and you two shall become one? But he says a man shall leave his father and mother and cleave to his wife, the two shall become one flesh. This was a prophetic writing that actually we found out later in Ephesians chapter 5. This is a prophetic writing of Christ in the church, mystery of old revealed through marriage. So marriage has a very historical, biblical, and a moral and ethical sense that's even brought into Christ's relationship with the church today. So when you look at the marriage had two fundamental aspects. Number one, there was always a covenant associated. A covenant, the word is important to know that when you look at the Old Testament, you won't see the word contract in there. So nowhere does it have they didn't make contracts in the Old Testament. Contract, the fundamental understanding of a contract is a this for that, quid pro quo. You're exchanging something of value, and is basically for a short period of time. When I give you this, you'll give me that, and then the contract is over. A covenant is a lifelong contract. So if we had to look at a contract terms, we had to say that a covenant was the Hebrew word for covenant, was used for agreement, but there was another word that was commonly used with covenant, and that's kara, and that actually means to cut or cutting. So the actual word that you would see in the Hebrew Bible regarding marriage is to cut a contract or to cut an agreement. We use that terminology today when we say to strike a deal, right? To strike a deal is the same type of thing, or to cut a contract. You're looking at actually taking, and the cut word, according to the biblical sense, we see that in Abraham in Genesis chapter 15 and Genesis chapter 17, where God made a covenant with Abraham, and God had Abraham cut the animals in two, and then God passed through the animals as a smoking furnace and a fire by night. And this symbolized the covenant, the everlasting covenant. So it's important when we look at the Old Testament, we can see, well, if man and woman make a covenant, what exactly is a covenant? We can look at how God made a covenant with man, and that's basically taking an animal, splitting it in half. That's where the word cut comes from, and that promise is dedicated through blood. And as we know in the Old Testament, life is in the blood. So you're making a lifelong contract or a lifelong agreement with another person in marriage. Does that make sense?
Yes, it does. What doesn't make sense is when you go to get married, they make you go to the courthouse and get a marriage license. That's the
right.
part I never could understand, why I had to go in there and do that. Why can't a minister or a priest just marry you?
Right. And that's a great question. And the reason is because the state wants authority of marriage. When you look at marriage, most of the law in America came through English law. And when you look at English law, all marriage, divorce, custody issues, all that was handled through the Church of England for 400 or 500 years. And then in 1857, on the Matrimonial Clause of 1857, a couple of the feminist women, went to Parliament, especially Carolyn Norton was kind of the head of this. She was a famous poet and writer. And she went to Parliament and she said, hey, you know what, women, we want a right to divorce, because the Church of England at that time, because of what the Bible doesn't allow women to divorce. You won't see women allowed to divorce their husbands anywhere in the Bible. So the Church of England did not allow women to initiate divorces throughout all of history. Matter of fact, I think in 400 years of English law, there was only around 352 divorces in 400 years, and only 2 of those were allowed to be initiated by a woman. So what happened was the women went to Parliament, said, "Hey, we got a huge problem. We want to have the right to initiate divorce." Parliament agreed, and actually took the authority away from the church, and that was the Matrimonial Clause of 1857. So in America, America wanted to go ahead and do the same thing. You know, the government, American government, we wanted to have authority over marriage, because marriage was exclusively a sacrament of the church at this time. And so it was is basically you reported to the state. You didn't ask the state for permission, because marriage in itself is considered an inalienable right. That means a non-transferable right. If the state doesn't give it to you, the state can't take it away from you. That's kind of the generalized definition of unalienable rights. But what happened was the state doesn't give marriage. It's a human right. Marriage is a human right that's been throughout all of history. But however, when they license something, what they're actually doing is they're having the power to say no. And when you have the power to say no, you're basically taking authority of that entity. Now, on unalienable rights, it's actually unconstitutional and against the Declaration of Independence for the state to license anything that's an unalienable right, to be able to have the permission to say no. But what the state wanted permission. Originally, the state said, well, hey, we want marriage license because we want to stop blacks and whites from marrying each other, right? And so that was the original excuse. And that's how the marriage license came into being. And then later it was, hey, we don't want to transmit sexual diseases. So it required, because after the black and white issue was taken care of, right, then you think that, well, marriage licenses wouldn't be needed anymore. But the state was like, well, you know what? We take that back. Now it's no longer a black and white issue. Now we want the power to say no for marriages because you might be transferring sexual diseases. And that's why you had to start getting blood work done to get a marriage license. And so it just really, excuse after excuse, the state just really wants that authority and power over our unalienable right, which is a human right, which is a unilateral promise of the Declaration of Independence. And that's why it's important, which we'll talk here in a second, why it's important to understand unilateral contract law, because the Declaration of Independence has unilateral promises in it.
Okay. Yeah, because they don't even do blood work anymore with these marriage license. Yeah.
That's right. So it's just once the state has control, or the government has control of something, they will never relinquish that control back, even if it was supposed to be for a temporary thing. And that has always been the function of the government. Once they have power, they do not release power unless they absolutely are forced to. Mm-hmm. And so the marriage license is unconstitutional. Basically against the Declaration of Independence, unalienable promises, because what it does is it violates our inalienable rights because it gives the state power over a sacrament, something that the state never had. And you're dealing with all of history, right? Through all of history, mostly marriage was handled as a religious institution. It was not controlled by the state.
Yeah, that's. I always wondered about that. But continue. I don't want to interrupt you because we're.
Oh no!
You're doing great.
So, and I just happened, I wrote a book on this, as you know, and I just happen to be very familiar with a lot of these issues on connecting the dots between, religious law and biblical law, right? Because most of the foundation of our law, or English law, is based on biblical concepts, such as equity and other things. They're based on biblical concepts brought into the law, coded mm-hmm. law. Knowing rights and wrongs and ethics and codes and morality. Because when you're looking at England, you had the Church of England, and you had the Pope was just as powerful as the king for a lot of that history, a lot of that English history. So a lot of the Catholicism or canon law ecclesiastical law, that had a big, or ecclesiastical courts had a big role in English law. And so, and that was brought over into America as well, that religious institution that tied in, religious rights and freedoms into basic civil law. So it's just a huge violation. So marriage licenses in itself is completely unconstitutional because it violates the First Amendment, as well as probably a few other amendments, but definitely the freedom to express religion, and the freedom to be able to marry to who you wish. And because once the state has the power to say no, they basically take authority over that right. The reason, like I said, it was originally started from the government was because the government wanted to give women the ability to initiate divorces in 1857. That actually transferred into America because, remember, during this time up until 1857, feminism started in England about 10, 20 years really earlier than in America. And America's feminism actually learned from the English feminism. And England's feminism was very violent. They were outspoken. They were they were very political. They're breaking windows, just like Black Lives Matters. However, the American feminists, historically, when they first started in the early 1800s to 1850s, they took more of a peaceful route, but they were also very smart, and they took a political route as well. But the women, actually, it's interesting when you understand marriage, is that women were not allowed to initiate divorce as well in the United States. Now, this is through common law, because when you're dealing with law in England and the United States, there's two different kinds of law. There's coded law and common law. We are basically considered a common law nation, as well as England. How that happened, or how that originated, was when England was basically in the 11th century, 10th century. What happened was the king made these traveling courts, and these traveling courts would actually travel and go from town to town and town, and they would make case law, or make decisions, and that turned into case law, that turned into precedents, and that turned into common law. Once you have enough cases that were ruled the same way, that basically turned into what was called common law. And the king wanted to control the people, and so they were not based on coded law, meaning they didn't have a huge list of do's and don'ts on the written law. But what it was mostly decisions that were made by the judges in the courts. So it's important to understand that the judge ruled the English people through the court system. That's where the Magna Carta came from, because the Magna Carta, the lords were saying, well, wait a minute, the judges were putting immoral judges in these traveling courts, and it was controlling the people and taxing the land. And so what the lords of the area, and those were the landowners, the lords of the areas, forced the king by knife point to sign a Magna Carta saying, you have dirty judges, just like we have today in the family courts. You have dirty judges that are adjudicating and making decisions for favor of the king, and we want to be ruled by our own people. And so that's where the whole jury came from. And the reason why this is important, because family court was originally had juries in them. It was originally through the civil courts, and also the criminal court system, because it had to do with finances such as child support. But what happened was, in 1910, the states and the government really wanted the ability to have a more fluid decisions or remedies to be made. And so what they did is they expanded the power of the judges, called these special courts. And they call these courts special courts, courts of equity, in 1910. And they based that on the Constitution, which says that when it talks about law and equity. But long story short, when you're dealing with why family court was originally designed, it was originally designed to actually supersede common law and to go around the need for juries. And the reason why that's unconstitutional today, original family court, is because what it does is it gives the judge all the power of the supremacy of the king, and that king was able to make decisions that were unquestionable. And that's what you're going to see in family court today, that these judges, when they make discretionary decisions, they become little gods, or they become little kings, and that their decisions are really unable, or almost unable, to be overturned, even in the Court of Appeals. And that's because courts of equity were originally appellate courts, meaning that if you went to a common law court, you got a bad decision, then you would go to a court of equity to get more of a fluid, more of a decision that was that they thought was more of a better remedy. But what happened was, now we do it the opposite. We go through family courts, and we go through courts of equity. And if we don't like our equitable decision, then we go to courts of law, called the appellate courts. And we tried to have the courts of law supersede equity courts. And that fundamentally cannot happen. Equity court was always designed to supersede common law courts, not common law courts to supersede equity courts. So in America, we kind of got the family courts backwards, and we made the marriage licenses a requirement so that the government could gain control of not only a marriage on the front end, but more importantly about divorce on the back end.
Mm-hmm. Well, when they got rid of these juries, I wonder what happened. If there was an uprising, do we know that? I mean, when all that happened?
No, in America or England?
Well, I guess in England, I guess.
So in England, the uprising came through the Magna Carta, right? They forced the king by knife point to have to be judged by a jury of their peers. However, what happened was, the first Magna Carta, after the king signed it, he rejected it, and he didn't follow through. So the Magna Carta was, I think, signed twice by two different kings, and then eventually it was ratified by a different king, and so the whole Magna Carta took a long time for it to happen because government was pushing back. Now, even Gandhi spoke about what I've heard, that Gandhi spoke about the Magna Carta, because Magna Carta was basically the human rights of the people. When you're looking at it, we have the Declaration of Independence. The Declaration of Independence, the promise for the unilateral promise for life, liberty, and pursuit of happiness, that is the government promising to us, the citizens of the people of the nation, that your human rights will be protected, and that we have certain human rights that are fundamental, and that England, at the time of our rebellion from England, we said basically, hey, England, the King of England, you're violating our human rights. And human rights is a God-given, nature's God's given fundamental right. And the king, they told the king, you have no reason nor power to violate our human rights. Those are from God, not from man. Those are unalienable. And so what happened was, when you look at the Declaration of Independence, things get a little confusing with people, because when we look at the Declaration of Independence today, and as far as in the court of law, we say, well, the Declaration of Independence was not meant to be a law. The Constitution was meant to be the supreme law of the land, right? Article 6, Section 2, the Supremacy Clause. So the Constitution was meant to be a law, but the Declaration of Independence was not meant to be law. So what happens in today's court, you don't hear people using Declaration of Independence arguments in the family court. Right. However, the Declaration of Independence has more power than the Constitution. It was designed to have more power than the Constitution. It was written and signed by the authors and the founders of the United States of America. Therefore, it became a contract. Now, when you're looking at a contract, what makes a contract and what doesn't make a contract? A contract is a ratified agreement, right? So if just to say an example, say you and I agree that we're going to go into business together and buy and sell bicycles, right? Now, you and I can just say we're going to do it, but it doesn't necessarily make it a contract. But as soon as you and I shake each other's hands, sign a piece of paper, right, do something that shows ratification of that promise is therefore now a contract, right? And contracts are actually protected in the Constitution. So private contracts, the government does not have powers over private contracts.
Mm-hmm.
When you make an agreement that's a ratified agreement, either through signature, handshake, some kind of ratification process, that agreement turns into a contract, and that contract is enforceable by law. So when you look at historically, when you look at how the founders looked at the Declaration of Independence in the United States Supreme Court, they always dealt with the Declaration of Independence of having the force of law, even though it was not law, or having the force of a contract, which many professors would call the Declaration of Independence today a unilateral social contract, meaning
Mm-hmm.
that the government made a promise to us. We never made a promise to the government. However, it is a promise for performance contract. What that means is that when we become citizens, when we actually we fulfill our performance. So like this, like they can't force you to become a citizen of the United States, right? You can't be forced to do that. So when you become a citizen voluntarily, then you're able to receive all those unalienable promises in the Declaration of Independence, and that's because you are going to perform as a citizen and do civic duties,
Mm-hmm.
such as you might pay taxes, join the army. There's many things that you do that will help society and will do your civic duty, and by performing your civic duty, it bonds the government to ensure and to protect your unalienable rights of life, liberty, and the pursuit of happiness.
That's excellent. That
So,
explains a lot. It really does. It's a
yes.
history lesson, and it explains it clearly. Thank you.
Oh yeah, no, thanks. It's and I know this, a lot of it's confusing, but it's very simple when you understand the Declaration of Independence was not only was it it was declaring our independence from Great Britain, or England. It not only
Mhm.
declared our independence, but what it did is what is called, when you're dealing with contract law, you're going to have two different types of promises. There's express and inexpressed, right? Or indirect promises. So when you're dealing with a preamble to the Declaration of Independence, where it says life, liberty, and pursuit of happiness, you can see very clearly that even though it doesn't say, hey, we the government promise the citizens of America life, liberty, and pursuit of happiness, well, what it does is it's called indirect promises that are made in the Declaration of Independence, because a lot of attorneys and lawyers and judges will argue, well, the Declaration of Independence was never meant to be a contract. It was actually just declaring our independence from England, from Great Britain. Yes, that is true, but it also had indirect promises that promised the people that we won't violate, that we the government promise that we will not violate the inalienable rights as Great Britain violated our inalienable rights. And it
Mhm.
gives us a certain what's called enforceability factor in the Declaration of Independence. And it says that when our own government becomes so tyrannical over a long abuses of our inalienable rights, we not only have a right, but we have a just duty to overthrow such a government and to put into place new securers of our inalienable rights. So that's a statement in the Declaration of Independence, paraphrased. But the understanding is simple: is basically that if we become a terror like Great Britain was to us, our founders gave us permission as we the people to overthrow our own government and to put a new government in place to secure our rights. And
Mhm.
that's the basic foundation of any government, is to secure the rights of the people.
Mhm. Definitely. Um, why do you think, I mean, as far as juries for family court in the United States, why can't we have juries there? Everyone's asking, why can't we have a jury in family court?
And we have to have a jury. So the question is that it's unconstitutional not to have a jury. What the states did. Now remember, federal government, the states individually took charge of marriage. They started to individually to do these marriage licenses and other things. And the function of the federal government was to protect the people from abuses of the state. That was not the case in 1833. So when you're dealing with the 1833 case, let me go ahead and get it real quick, of Barron versus Baltimore. Barron versus Baltimore is a very important situation, because in that particular case, the federal government said, well, the Bill of Rights were not designed to protect people from their own states. It was only to protect the people from the abuses of the federal government. So what happened was, in 1833, the states were able to abuse the inalienable and alienable rights of all the people, and the federal government promised they would not get involved. And then, so you started to see that in, like I said, family court was designed in 1910 to around 1919 through all the independent states, but it actually transpired very fast. Family court, obviously divorce or remarriage and marriage, that was handled through the courts before the design of family court in 1910. So it was done through the civil courts and the criminal courts, where they actually did have juries. So at one point in time, divorce and divorce court or family court, or I should say divorce in itself, was handled with juries, because the Constitution says, hey, anything over $20, that the individual has a constitutional right to be judged by their juries of their peers. Now, the reason why being judged by a jury of your peers is so important, because the founders didn't want our government to become as corrupt as England's government. And in England, they understood, like the Magna Carta. The Magna Carta ensured that the people would have juries. And the reason why is because the king was abusing the people. And so they thought, well, hey, if we judge ourselves or we rule against ourselves, it's less likely that we're going to violate our own unalienable rights. But what happened is these family courts became known as special courts, or special interest courts. And the states started to giving them all the power of, or all the supremacy of, not only the state, but also the federal government, because the federal government promised or vowed that they would not get involved with state matters of domestic relations. So that's how come, if you have an inalienable violation or a civic violation in your state, the federal court refuses to get involved, because they say, well, hey, marriage is a state issue, it's not a federal issue. However, that is not the case anymore, because since 2000, with Troxel and Granville, and then in 2005 with the homosexual United States Supreme Court, as well as all the federal laws regarding Title 4D and child support and all these other things, the federal government sure has their hands dirty now in marriage matters and laws, and as well as the United States Supreme Court. So in reality, marriage is no longer just a state issue. Now it's a federally regulated issue in so many areas that it's impossible, to the point now, for the federal government to stay out of this. Mm-hmm. But as I mentioned before, the federal government is, you're going to find out that most of the government are going to be lawyers, and through the Bar Association. 60% of all Congress in the House and the Senate right now are bar-carrying members. Most of those are attorneys, or a lot of those are attorneys. Historically, 75% of all of Congress was through the bar. And when you're looking at the bar is a there's a really neat historical reference to the original 13th Amendment. I won't get into that show now, but the original 13th Amendment prevented people from being certified through the bar and being able to hold positions within the state, because they looked at the bar as a British accreditation registry and said, hey, you can't have, the original 13th Amendment said you can't have titles of nobility and basically, have a position of government in the United States. But however, there was a question on the ratification, if it was ratified by 13 states or 12 and a half states. And there was a big question of that from, I think it was like 1812 to around 1875. But the big thing is to know that when the Bar Association got involved, and that was basically 1875, you have the Bar Association started with just like basically 20 lawyers who kind of decided to do a club med together. Then basically, I think it was by the early 1900s, I want to say 50% of all lawyers were bar certified. And basically, people don't understand, the bar does not license lawyers. The state licenses lawyers. People are licensed to their state to practice law. What the bar does is the bar is just a club where you actually pay dues. And so it's almost like a union of lawyers. And because of that, that has caused a catastrophe, because what the bar has done is it connected the legislative branch and the judicial branch together, as the majority of the judicial branch are going to be bar certified, because all the judges and all the lawyers are and the guardian ad litems, a lot of the guardian ad litems, and then you have 60% or over of Congress through the bar. So this monopoly of the Bar Association, it came out to be very left wing and liberal, is that, and they're fighting against anything to do with the family court, and they're fighting legislation is fighting against any kind of bills to be passed through for family reform, because of this direct ties that the legislators has with the judicial branch through the Bar Association.
Mm-hmm. Yeah, that's why they put Esquire after their.
That's correct. That's right. That's right. Because it was a title of nobility from England, the British Accreditation Registry, that basically said, hey, and that was the problem, because the problem with the original 13th Amendment said, hey, you can't have a title of nobility from a different country and then serve the government here in the United States, because the question was, who are you loyal to? Are you loyal to England, or are you loyal to America? And that was the original intent of the first 13th Amendment before it basically got washed out.
Oh, that's interesting. What do you think of parents patriae and this best interest of the child standards? Because it's just gone
haywire.
It's
supposed to go haywire. And it's supposed to go haywire. That's the original intent. The original intent of the best interest of the child standard was, when it was first used in America, a particular judge, as the story goes, a particular father had rights over his children. Somehow as he gave his children to somebody else to raise. That person died, had an inheritance, left it for the children. Father came back on the scene, says, hey, as the story goes, I want my children's inheritance, and I have a right because children were under property laws, which they were. However, what the judge did is said, well, wait a minute, this is not in the children's best interest for the father to get the money for the children. So the judge, as the story goes again, the judge superseded the parental rights and property rights of the father, with this term, best interest of the child. It's not in the best interest of the child. And you'll hear the term best interest of the child, such as Hitler used that term. And so, the best interest of the child is a very dangerous term, because it originated from what I believe was very clearly, there was a doctrine in 1608. It was called parens patriae, right? That's the Latin term for the parent. The nation is the parent of the child. Now, what happened was, when you're dealing with English law, is that English law had courts of equity at the 1800s, 1700s, 1600s. They had courts of equity by this time, and then they had courts of common law. They had two different types of courts. Courts of equity came from the king himself, and then basically they became too numerous for him to handle. He went to the Lord of the Chancellor, the Chancery, and he created the Chancery courts, and then he gave the Chancery the powers of the king. And this is called keeper of the king's conscience. This is where you heard that term. And he gave them all the power of the king to be able to, to adjudicate matters. And equity courts or chancery courts, what they use is they use canon law and civil law to make their decisions. So they base their decisions on equity or principles of equity, and they base it on the biblical precepts of the Bible through canon law, right? So canonization of the Bible. So that's the original intent of equity. Was the king says, hey, I'm supreme, I'll make moral decisions for the country. However, if I can't make those decisions, the next best person to make it is somebody high in the Catholic Church, because they can make moral decisions, right? So when you're looking at equity, you're looking at moral decisions, in which we have maximums of equity that were later designed from these courts of equity, saying that, hey, there's a basic fundamental moral and ethical premise of equity, because equity was always based on morality. It was never based on law. It was never based on codes. It was never based on standards. It was based on based on morality. And if the king wasn't able to make those decisions, he gave all that power and authority to the Catholic Church. And the Catholic Church had somebody in the Catholic Church was called the Lord of the Chancellor, and they turned those courts into the chancery courts. Now, it's important when you understand that, because what happens was the chancery courts were designed because the common law courts were very strict, and they didn't have good remedy. They could only give you like the financial worth of something if it was stolen, broken, or what was the case. And they couldn't really give flexible decisions, which we call a good remedy. So what happened is that the equity courts only handled a few matters. Now, one of the matters that the courts of equity did handle is they handled children who were abandoned in the orphanages. This is important to understand. These were abandoned children that were given to the orphanages, right? Because they didn't have, women didn't abort babies, right? Like they do today. What they did is they gave them to the orphanages, right? They dropped them off in the middle of the night in a basket. As well as then you have lunatics or imbeciles, that was the legal term that was used, imbecile. So it's not a derogatory term on my side at all, but that was the term that they used. But they says, hey, if anybody, an older person can't take care of themselves, or an imbecile, they said, or a child can't take care of themselves, then that parent will take on that role as the parent of that person, right? And they will make those moral and ethical decisions for that person, will raise that person. So the state became the parent of the children, but the state became the parent of only neglected and abandoned children. Well, you ask yourself, how did how did parents portray turn from, hey, the state will only take care of children in orphanages or in foster homes, to the best interest in the child standard is used, with fit parents all over the world today, right? And the reason why is because of the use and abuse of that parents portray doctrine. But what happens is the parents portray doctrine basically was in competition with parental rights. Parental rights under called Curvature Law, this is through the common law, it said that the man was the master of the house. So the man being the master of the house, all women, children, and slaves were under property laws from 1600s to the mid 1800s. And so the only thing that would supersede, and so the state had a hard time with fathers, right? Because you also have the rule of thumb at this time where men were beating their wives with a stick or a twig, which was called a twitch. That was, as long as it wasn't as bigger than your thumb, couldn't leave any marks on the body, couldn't draw blood, and couldn't be hit in the face. But however, these was still used, right, that men were using to control their women. So basically they were punishing their children or treating their women like children in a sense, and punishing them and spanking them in a sense. And this was very problematic at the time in the early 1800s. So what happened was the women, obviously, many of the women rebelled from these coverture laws. And so these coverture laws the women wanted to free themselves from property law. Women were like, we're not cattle. We want our constitutional rights, because as long as women, children, and slaves were under property rights, neither of them were able to have the full extent of the constitutional rights as a person. And that's important for people to understand. As long as you were under property law, under coverture law, until the mid 1800s, you didn't have full constitutional rights. Coverture actually came from the word to cover, and that was because a woman was considered to lose her legal identity, and she became the legal identity of her husband. And during this is important to know this, because many at this time, that if a child would say go and break somebody's window, or say your wife would go and break a law, the woman would not go to jail and the children would not go to jail. The man was held responsible for all the actions that were done by those of his household. So he was held responsible for those. He had to pay that back. The man was, even if the woman committed a crime, many times the men had to go to jail for their women's actions. Now, this is according to coverture laws, because you're dealing with property law. So what happened was during this time, and you'll hear about Mary in New York and the first CPS case and how CPS was created. CPS was originally, I think, created around 1875, 1860, around time period. And what happened is that, if you don't know the story, there was a teacher who went to this home and saw this severely abused, neglected child. And she went to the police and said, hey, police, you guys got to do something. This child is obviously super thin. She doesn't have any vocabulary. She has, bruises or cuts all over her body. She was actually a foster child. Her real mother, her real father died, and her real mother gave her up to the orphanage. So she was being raised by an orphan family, and the mother didn't love her and would take her abuse out on this girl. And this teacher who went and visited the house saw this child. I think she was around 9 at the time or something like that. Went to the police and say, "Hey, police, why don't you guys look into the matter? You need to protect this child." The police says there's nothing we can do unless we see it's a crime, and we have to see it's a crime, right? And according to crimes, like, you had to have witnesses, it had to be, had to be clear and convincing, or beyond a reasonable doubt. And so police says, in the most of the cases when it comes to abuse and neglect of children, there's nothing that we can do unless we literally see the act, which is almost impossible to see what's happening, at the homes. So, and that's because property rights were so strong at the time. So, and this is around the 1875s, 1860s. And then as time went on, this eventually, the story goes, is this teacher went to a society that was in charge. This was in New York. Went to a society that was in charge of looking after abused animals. And these two particular men who were leading the foundation, the women said, "Hey, why do horses and animals have more, human rights protections than children?" And these men in this society agreed. And so what they did is they started the first child protection services, which actually grew because they were looking for state and federal funding. And the more that they asked for state and federal funding, the more that the state and federal laws wanted to be involved. And that's how Child Protection Service was originally created. So when you're dealing with, and this is important, the history is behind it is important, because when you're dealing with the best interest of the child standards or parents portray or any type of doctrine that gives the government authority over a child from the parents, right? You have to separate. How do you separate the inalienable rights of the parents with that child, right? The DNA. How do you separate that without proving there's a crime, right? 'Cause that's the main thing. Because if there's a crime committed, that parent went to jail. And if that parent was in jail, then that parent could no longer parent the child, right? So then, you would basically have a relative or somebody else parent the child. However, in today's society, if there's abuse and neglect, they don't arrest the parent. They leave the parent and they take the child, in a squad car, and throw the child in a squad car and take them away, even though no crime has been committed. And these were all founded on the original parents portray doctrine in 1608 that said, the government said, you know what, we have the ultimate authority over children, even over parents. And there's always been a fight over children. Who has ultimate authority, the nation or the parents? As far as the Declaration of Independence is concerned, our children have, our children are the inalienable rights of the parents. And the state we have privacy rights. And these privacy rights were founded through the Constitution, that were supposed to protect from the government from interceding in the home and the family life. However, the parents portray doctrine was used in America, and eventually, I believe, grew into the best interest of child standards, because best interest of child standards has the same intent as the parents portray doctrine, and that's to supersede parental rights.
Yeah, that's scary. It's just very scary. Even today, people are losing their kids left and right.
Yeah, and that's because now there's a financial incentive, right? Because there's something called, because the federal government and the United States Supreme Court had a problem with something. It was what was happening was the federal government, and the state does this as well. So the federal government will create like all these committees, or create all these not only that, but they'll I forgot the word, subdivision, subpar, I forgot the word what it's called, but they would basically make contracts with certain individuals, like you'd have guardian ad litems, or you'd have child evaluators, right, who people who are not working through the state or the government, but they would be given the power of the state and the government, because a judge would give them that power through a court order. So you have a problem, because they created these committees, and they created these child protection services through human service programs, or human service department. and there's a financial incentive for the states to take children away from parents. They get, there's 60 cents every dollar, as you know, Title 4D and E, but Title 4D specifically is that the more that the state, if they take the same number of children away from parents that they did the year before or more, they'll receive a certain level of federal funding. And so the pressure from the state is to always be able to match or excel the number of children through that the Child Protection Services or DCF or whatever the names are, because they have different names for human services in different states, but to be able to take away the same number of children that they took away the year before, to be able to capitalize on that federal funding. And that federal funding becomes a blank check to the state, and they become to depend on that federal funding. So once they become to depend on that federal funding, they can't lose that federal funding. So anything to do with, it's called, child support reimbursement, and acts. But a lot of this was really set up during the Clinton administration. Clinton administration set a lot of this up. He's set up the, I think of VAWA, Violence Against Women Act. We also have the, I want to say CAPA. We have a lot of different things and also the Forced Adoption Act that says, hey, if your child's in the foster care system because you're fighting, and the foster care system, or the CPS and the government's playing games with you and have you running through all these hoops for 2 years, after 2 years, those children are available to be forced adopted. And they're taking these children now and they're putting them on medication and getting them to specialists, like such psychological things, because the state makes money off of that as well. And the state will claim, well, we don't make money off of that. It'll cost us money. But realistically, each state receive millions of dollars each year through the Title 4D to actually take children away from their parents. And so if you look at the family court compared to the criminal court or civil court, the family court is the darling of the court system. They generate more money through that than any other, probably all the courts combined.
Oh, it's just sick. It really is sick that they're doing this to families, and these children are taken away for sometimes false allegations, things that are just made up.
Yeah, and they're made up because there's pressure on and if you think about it, right, if I'm at McDonald's and I don't make enough, if I don't make enough, Big Macs, I'm going to get fired, right? If I'm not working fast enough and producing enough, I'm going to be fired at McDonald's. Now, when you get hired at McDonald's, there's nothing that says, hey, you have to make 6 cheeseburgers and 5 fries and or take this many orders an hour. However, if you don't perform, you'll lose your job. So and the same thing happens, like a lot of police, they'll hand out tickets at the end of the month, because the way that the pressure on the police is that they're saying, well, hey, a certain number of people statistically are breaking laws, so each policeman should be able to give a certain number of tickets out a month. So at the end of the month, you'll find out that a lot of pressure on policemen to actually hand out tickets. And so the same thing too with Child Protection Service agents and field agents and DSF agents and human service agents. If they don't get enough children out of the parents' homes, because they look at statistically how many bad parents there are, and they take that through how many bad parents that they took away from the kids last year and the year before that, then they'll just simply say you're not doing your job. So there definitely is an expectation from these field workers to take children away from home, even though they'll deny it, as well as a police officer might deny handing out tickets at the end of the month just to meet his quota, or that somebody at McDonald's might deny making enough, if they don't make enough cheeseburgers, they'll get fired. But it's what happens is you're dealing, whenever you put the government into the family environment, the inalienable rights. The Second Amendment is important to people to understand. The Second Amendment was created. It says, hey, if you have any enemies, foreign or domestic, that come into your home and try to take your wife or your kids, any of your inalienable rights, you had a right to shoot them. You had a right to stop them. That was the original intent of the Second Amendment. It was to protect your home. However, and that's the home was a king's castle. However, Child Protection Services, policemen, all those other things, and even the government, they have infiltrated the family home to the point of that they don't even consider parents. They don't even consider children property of the parents anymore. They consider children having their own constitutional rights, even though historically they've always been part and parcel of the parents' constitutional rights. And what they do is they say, well, we're trying to protect the child. And then what they do is they end up, the only way that they know how to protect the child is to take the child away from a parent that's questionable, and to a point that they feel safe where they can return it to that parent. So they always, the government says, hey, we always err on the side of caution, but the Constitution promises that the government can't err on the side of caution. And the criminal laws promises us that the government can't err on the side of caution. It says you're innocent till proven guilty. However, when you're dealing with the family, you're guilty till proven innocent.
Yes. Yeah, I agree with that. Been there, done that. So is there anything else you would like to add?
So a lot of people are saying, well, how do we get out of this mess? Right. And we're like, how do we fix the situation? Is it reversible? There's an old saying that, I don't know if you're familiar with this, but if you catch like mold starting in your home, you can cure it if you catch it early enough, or cancer. There's a lot of things that you can catch. If you catch it early, you can get rid of it. However, if it becomes too bad, then you literally have to cut stuff out, or you have to cut the wood out of the home, or you have to, remove some, who knows, organs from your body if it's, if it's uncurable, comes to that point. And the question is that has United States became to a point where we're so tyrannical, like England was towards us, that we're unable to be cured as a nation? And the answer to that question is that is our nation still based on biblical premises, still based upon the moral and ethics of the Bible? And do we still have our religious rights and freedoms? And the unfortunate answer to that is no. And the fortunate answer is that not only do we not have religious freedoms, well, here's something that's important for people to understand. When the Bill of Rights was designed, and when it was originally created, it wasn't created like a map saying that, hey, this is number one, this is number two, number three, by others. It was basically saying the Federalists were basically were put together like, if we have to look historically, what are the first rights that are taken from the citizens, from the government? Let's go ahead and put an order together. And let's put an order of importance together. So when you see the First Amendment, right, the freedom of speech, freedom of religion, freedom of the press, that's because historically you're going to see, when you look, that was put together through historical records, but historically you'll see that right was taken away historically by the government. And then the second right that was taken away from the government was the right to be able to own arms, right, to be able to defend yourself. And then so basically when you look at the Bill of Rights 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, you can almost go in order and see how bad, the report card, use it as a report card to see how unmoral and unethical America is. And like I said, once it comes to a point where the mold has actually grown to that point, you have to cut that mold out and you have to replace it. But right now you're seeing an attack by the government on your Second Amendment rights, because they don't want the government wants to protect themselves because they know that a civil war is imminent if they continue down this road. And they have no plans on stopping. So what they're doing is they're trying to take that Second Amendment right away from the individuals to be able to stop a second civil war. And they've actually succeeded, because the Second Amendment was that we were supposed to be able to be as armed as the government itself, that we can defend ourselves from the militia. However, they've limited, saying, you can't own machine guns, you can't own automatic weapons, you can't have a certain number of bullets in your gun. And so through those small, they have chipped away that Second Amendment right, where you basically just have a small little pistol for home invasion, but you don't have anything to protect yourself from a corrupt government anymore. The government, when the government's at a point now with all of its tanks, its airplanes, and so forth, that if we decided to do a civil war against the federal government, we wouldn't have a chance anymore, as far as, in my opinion, according to, if you look at the number of guns or the type of weapons that the government has and that the regular citizen citizen has a home. But that's an intent. So once you lose your Second Amendment right, then you're going to lose all your other rights.
Mhm.
And they'll be very blatant about it. So you'll see the states individually starting to take away rights, because the rights are in the Bill of Rights is incorporated through the 14th Amendment. And the 14th Amendment says that that the state, long as the state gives you a hearing or a court ruling where you go to court and able to present witnesses and testimony, and if they rule against you, the federal government a lot of times will not override that that state court's decision based upon a twisting of the 11th Amendment or the Rooker-Feldman doctrine in the family court, domestic relations exemptions. You'll hear all that. But what happened was the 14th Amendment was originally designed to supersede state courts' decisions. But what happens is that the Supreme Court has twisted it so bad that there's almost no remedy for us in America anymore to be able to, because historically the criminal court system has always been somewhat corrupt. That's just historically, but because you're dealing with liberty rights and so forth. But now it's come to a point that family court is totally corrupt. And the question is America able to be saved? And if we did a civil war, is there any way that we could replace the governmental leaders, the tyrannical, through a long trail of abuses, and actually establish a new government? Is that even possible now? Do we have the military power to do so? And I don't think that's the case to do that. So I think that we're in a place now, and not to give up, but I think that we're in a place now that we're going to see that implosion that you see in most, historically, most, nations, they implode. They're not conquered by other nations. Great nations usually are destroyed from within. And I think you're going to start seeing that in America. First will go morality. And then secondly, you'll have the governmental abuses over the citizen, and there will be no recourse. And there pretty much is no recourse in family court right now.
That's very true. There is no recourse and there's no remedy at law with family court whatsoever.
Right, and that's through the domestic relations exemptions, Rooker and Feldman doctrine. There's a lot of ex parte young. There's a lot of doctrines that they throw out there to just for the federal government to overturn these civil right abuses by the state courts. They refuse. However, now the question is, well, like an example, we have Troxel versus Granville. It says, hey, every fit parent, should have care, control, and custody of their child, and you have to have unless you have a fitness hearing with clear and convincing evidence that you're found to be an abuser and neglector of children. And so, but what happens is that people still have 0% custody of their children. The government is still able to violate this Supreme Court ruling, and there's no recourse. They say you can't go through the federal courts because of the Rooker-Feldman doctrine, and the United States Supreme Court's not going to take an individual custody case because they'll only take cases that are a thing of national importance. So there is no remedy in the federal court system.
Well, I sure learned a lot from you today.
Oh, sorry.
Yeah, no, that's quite all right. Well, I'm going to have you back on again. I think you're a wealth of knowledge, and we need to learn from you. Is there go ahead.
Well, one thing is really great too, just to let you know, there's two different things going on right now. Is that there's the 50-50 shared custody bills. Those are actually wonderful. The reason why that those are wonderful, and though they're not biblically based, and there's a lot of reason for that, but when you're dealing with unilateral no-fault divorce, and you're saying there's no one at fault, you really can't take away that. With Troxel and Granville and other Supreme Court rulings, you really can't take away that custody from the other parent. There's still a constitutional right to be able to raise your child, and the grandparents and of both sides of the family and so forth. But we have the 50-50 shared custody bills are going to be wonderful, because what it's going to do is it's going to bring the federal court system, hopefully being able to bring in when state judges violate that 50-50 shared custody statutes, we might be able to get some state Supreme Court or some federal laws or regulations to be able to prosecute, not only prosecute the judges, but hopefully be able to reverse the decisions. And I think that my thoughts is that we'll probably see that. We also have a lot of people who are pushing for a parents amendment, right? A parent-child amendment. So creating another amendment that actually brings in and says that that parent-child relationship is an inalienable right, and create an amendment that will actually protect the states. And historically, when you're dealing with civil rights movements or the women's suffrage movements and the rights of women having the right to vote, whenever you create an amendment, that amendment really brings in the federal government. So we could possibly get into some federal government. But as far as having any kind of oversight in the judicial system, I just don't see it.
Mm-hmm, mm-hmm. Well, I'm glad I had you on. I don't want to steal your whole evening away from you.
Oh no, thanks for letting me share.
Oh, most definitely. And I will have you back on.
Yeah, well, it's it's just we're just keep on fighting. The wonderful thing about Zoom is that it has allowed a lot of people to actually get recordings of their hearings, and that has brought a societal or a social accountability to these judges. And I
Mm-hmm,
think that we're going to see something really good happening from these Zoom hearings
mm-hmm.
being brought out to light.
I agree. I agree. Thank you so much.
Thank you.
Okay. Slam the Gavel is a podcast to help the public understand what really goes on in the family courtrooms and in turn perpetuate parental alienation. I'm your host, Marianne Petrie, author of Dismantling Family Court Corruption, Why Taking the Kids Was Not Enough, and Cry Out for Justice, Poems of Truth. Please join us again with Michael in the future. We'll have him back on and other guests. So thank you so much again.
Hey, thanks. Cool. How did that turn out? Did it make